Assalamu alaikum, good evening, welcome to the Ask Aman Livestream. This week we've got a packed program for you again. We will be talking about different areas of law. But before we start the live stream, I just want to play you a couple of short videos. Here's the first one. Welcome back. That's just the legal spiel. You wouldn't be on a legal live stream without the disclaimers. Of course, this show is for general advice and general guidance. If you need to do anything regarding anything legal, immigration status, family matters, employment, or otherwise, you must take legal advice from a qualified and competent professional before you take any actions, because getting it wrong can have serious consequences for you or your loved ones. And that is very important, because fixing a mistake is very, very difficult, and avoidance is better than the cure. Short introduction to the services, and then we'll go straight to our first guest.
Aman Solicitors Advocates. From our offices in London and Luton, we represent clients across England and Wales. We specialise in civil and commercial law and litigation, divorce, child custody, contact and family law, all areas of personal injury, accidents at work, trips and slips, family and business immigration, nationality, asylum, deportation and detention law, wills and probate, employment law for employees or employers, charity law and disputes, public and regulatory law. Our professional and committed legal team will provide you with a first-class and competitively priced service. Aman Solicitors Advocates, your firm of choice.
Welcome back. That was just the introductory video. Now then, we're going to go to our first speaker, our colleague and solicitor, Mr. Sadiq Subhani, who will be talking about immigration extensions, and he will also be looking at what to do if you have lost a partner who has passed away during these times, these testing times, and you need to extend your visa because you were dependent upon your partner or husband or wife. So I'm going to bring in my colleague, Mr. Sadiq Subhani. Assalamu alaikum.
Walaikum assalam, Bisharat Saab, Saad Saeed, also assalamu alaikum, and the viewers. Hello, assalamu alaikum, adab. तो मैं उर्दू में ज़रा मेरे पिछले प्रोग्राम की तोसी ही समझे एक्सटेंशन उसकी लास्ट वीक जो किया था उर्दू में, तो उसमें मैंने बात की थी जो स्पाउस वीज़ा एप्लीकेशंस होती हैं, अज़दवाजी वीज़ों के मुतालिक जो दरख्वास्तें होती हैं, तो उनके मुतालिक बात की थी कि वीज़े की दरख्वास्तें जो हैं वो कैसे कैसे डाली जाएं, क्या क्या लाज़िमात होते हैं। और आज जो है वो मैंने उन्हीं वीज़ों की हमारी आप जो है वो दुआ और मेहनत और आपकी जो मेहनत होती है और आपकी जो ख्वाहिश होती है उसके तहत जो कुदरती मेहरबानी से आपका वीज़ा हो जाता है। तो जब आप यूके में आते हैं तो यूके में फिर आपको आपने उस वक्त में कुछ वाक़यात हो सकते हैं या जो आपको 2.5 साल का वीज़ा मिला होता है और उसके अख्ताम पर आपने उस वीज़े की तस्दीक लेनी होती है। तो आज जो मैंने बात करनी है वो उनके मुतालिक बात करनी होती है कि आपने जब यूके में जो दरख्वास्त गुज़ार होते हैं वो आ जाएं, तो उसके बाद उन्होंने किस तरीके से फिर आगे जो है वो तस्दीक लेनी होती है। तो मेरी इस एडवाइस से पहले जो जैसे बिशारत साहब तो इंग्लिश में डिस्क्लेमर पढ़ते हैं, तो मैं उसको उर्दू में तशरीह ऐसे कर दूंगा कि डिस्क्लेमर यही होता है कि जनाब नफ़ा नुकसान के जिम्मेदार आप हैं। जो हम ये एडवाइस कर रहे हैं ये उस तरीके से कर रहे हैं कि जेनेरिक जिसको कि एक आम से हालात में उस तरह के करते हैं। ये किसी मखसूस एक बंदे के हालात के बारे में नहीं होता, क्योंकि हर बंदे के, हर जोड़े के, हर दरख्वास्त गुज़ार के हालात अपने अपने होते हैं। तो उसके लिए जो है कोई स्पेसिफिक एडवाइस जो मखसूस जो मशवरा होता है वो ज़रूरी होता है। तो ये है कि आम सूरतों में आपने क्या क्या चीज़ें जो करनी होती हैं, ये नहीं कि आप बिल्कुल इसी तरीके से करें। तो वो जैसे हमारे वो होता है ना अपने मुल्कों में जहाँ जहाँ उर्दू, पंजाबी, पहाड़ी, पटवारी, सराइकी ये ज़बानें जो है बोली जाती हैं, تو وہاں ہمیشہ جو ہے آپ نے دیکھا ہوگا کہ وہ جو ایک ڈرائیور ہوتا ہے تو کنڈکٹر ہوتا ہے، تو کنڈکٹر ساتھ میں بعض کا کہتا ہے استاد جی اپنی ذمہ داری تے جان دو ہے جی. تو جناب یہ آپ کی اپنی ذمہ داری ہوتی ہے، جو بعد میں وہ چیزیں ہیں. یہ جو ہماری ایڈوائس ہے یہ جنرل جو ہوتی ہے وہ مخصوص آپ کے کیس کے متعلق نہیں، لیکن جنرل ہوتی ہے کہ آپ یہ چیزیں کریں. تو اس وجہ سے نفع نقصان کی ذمہ داری جو ہوتی ہے اس صورت میں اگر کوئی چیز آپ خود ہی کرتے ہیں تو وہ آپ کی ہوتی ہے، وہ ہمارے ذمہ اس طرح سے نہیں ہوتی ہے. تو آج میں نے پہلے بات کی کہ وہ جو ازدواجی ویزے ہوتے ہیں جن کو اسپاؤس ویزا اپلیکیشن کہتے ہیں، اللہ کرے آپ یو کے میں پہنچ جائیں تو ان کی توسیع جو ہے وہ کیا. تو وہ جو 2.5 سال کا عرصہ جو اختتام ہوتا ہے، اس کے بعد آپ نے ویزا ختم ہونے سے پہلے ویزے کی توسیع کی درخواست ڈالنی ہوتی ہے، اور اس کے لیے آپ نے لوازمات پورے کرنے ہوتے ہیں. وہ لوازمات جو ہے وہ کم و بیش اسی طرح سے ہوتے ہیں جیسے پہلے ہوتے ہیں. اگر آپ دونوں کی جو وہ دونوں حیات ہیں، دونوں جو شریک سفر ہیں، شریک حیات ہیں، خاوند اور بیوی دونوں، تو اس اختتام کے جو ہے وہ پر آپ نے جو ویزے کی توسیع لینی ہوتی ہے. اس میں ایک تو یہ ہے کہ جو تنخواہ جو وہ آمدن ہے تنخواہ اس کا جو حد ہے وہ بھی اگر ایک ہی وہاں سے خاوند آیا ہے یا وہاں سے بیوی آئی یا بچے نہیں تھے جن کے لیے ویزا چاہیے، تو ان کے لیے 18,600 کی ہی حد مقرر ہے. اور اگر بچے بھی ویزے پر آئے تھے تو پھر بچوں کے لیے پہلے بچے کے لیے 3,800، دوسرے کے لیے جو ہے وہ 2,400 کی ضرورت ہوتی ہے. اور اس کے ساتھ یہ ہے کہ بچوں کے لیے تو انگلش کی ریکوائرمنٹ نہیں ہے، لیکن جو درخواست گزار ہیں ان کی عمر جن کی 18 سال سے اوپر ہے ان کے لیے انگلش کا پھر دوبارہ سے ایک سرٹیفکیٹ چاہیے ہوتا ہے. لیکن اس بار جو ہے اس کا جو حد ہے وہ جو آپ پہلے بیرون ملک سے کر کے آئے ہیں، یو کے باہر سے کر کے آئے ہیں، اس سے ایک درجہ اوپر چاہیے ہوتا ہے. A2 جس کو کہتے ہیں، وہ آپ کو A2CFR جو لیول ہوتا ہے اس سے یا اس سے اوپر جو ہے چاہیے ہوتا ہے، بشرطے کہ آپ نے کسی انگلش کے اس طرح سے وہ کوئی ڈگری نہیں کی ہوئی ہو جو یو کے نارک کے کمپیریزن جو ان کا ہوتا ہے تقابلی جو جائزہ ہوتا ہے اس میں وہ ڈگری لیول سے اگر اوپر ہو تو پھر آپ کو تو نہیں چاہیے ہوتا ہے. لیکن اگر وہ نہیں ہے، جو زیادہ تر کیسوں میں نہیں ہے، تو پھر آپ کو لیول A2 کا انگلش کا سرٹیفکیٹ جو ہے وہ بھی چاہیے. اور اس کے ساتھ آپ نے شو کرنا ہے کہ آپ جو 2.5 سال گزرے ہیں، آپ اور آپ کا شریک حیات، آپ کی جو تعلق تھا، جو ریلیشن شپ تھی، جو رشتہ داری تھی، وہ برابر چلتی رہی ہے اچھے طریقے سے، اصلی طریقے سے، اس میں کہیں کوئی دراڑ نہیں تھی. تو وہ آپ نے ایسے شو کرنا ہوتا ہے کہ آپ جو 2.5 سال کے آپ کے نام کے خط، درخواست گزار اور سپانسر کے نام کے خط، وہ آپ کے مشترکہ وہ اکٹھے ناموں پر ہوں یا علیحدہ انفرادی طور پر ہوں، یا اگر بچے ہیں تو ان کے نام پر ہوں، وہ دکھانے ہوتے ہیں. یا بچے یو کے میں ہوئے ہوں، ان کے برتھ سرٹیفکیٹ دکھانے ہوتے ہیں، ان کے پاسپورٹ دکھانے ہوتے ہیں، آپ کے پاسپورٹ ویزا کارڈ، کہ یہ آپ کی جو ہے وہ فیملی اس طرح سے ہے. اور اس کے ساتھ آپ نے یہ ثابت کرنا ہوتا ہے کہ آپ کے پاس رہنے کے لیے سب کے پاس جگہ ہے، اور وہ جگہ جو ہے وہ آپ کرائے پر ہو سکتی ہے، کرایہ دار کے طور پر آپ یا آپ کے جو دوسرے اسپانسر ہوتے ہیں ان کے نام پر ہو، یا اسپانسر کا اپنا مکان، یا آپ دونوں کے نام پر ہو، یا اگر آئے ہیں اسپانسر کے والدین کے ساتھ، بھائیوں کے ساتھ، یا کسی رشتہ دار کے ساتھ رہ رہے ہیں اور وہاں کرایہ نہیں دے رہے ہیں، تو پھر یہ ہے کہ آپ مالک مکان سے آپ کو ایک خط چاہیے ہوتا ہے کہ ہاں ان کی طرف سے آپ کو جو ہے اجازت ہے وہاں رہنے کی. پھر ان کے آپ نے پروف آف آئی ڈی، ان کی شناخت جو ہوتے ہیں، شناختی دستاویز، اس کی بھی کاپی لگانی ہوتی ہے کہ ہاں یہ بندہ ہے، فرضی آدمی نہیں ہے. تو ثابت یہ بھی کرنا ہوتا ہے کہ جو بھی مکان ہے وہ ان کا ہے. تو یہ مین چیزیں ہیں. اور اس کے ساتھ آپ نے اپنا کردار جو ہے اس کے بارے میں بھی شو کرنا ہوتا ہے کہ آپ نے یہاں آ کے کوئی جرائم نہیں کیے، اس طرح کے کسی قسم کے کوئی سیول یا کریمنل جو بھی جرائم، جس طرح کے دیوانی یا فوجداری جن کو کہتے ہیں، تو اس طرح کے ایسے کوئی جرائم آپ کے ماتھے نہیں لگے. تو یہ مین چیزیں ہیں کہ آپ نے ان کا خیال رکھنا ہے. اور اگر وہ پوری ہوتی ہیں تو پھر مزید آپ کو 2.5 سال کا ویزا پھر وہ توسیع ہو جاتی ہے. لیکن بعض صورتوں میں یہ بھی ہوتا ہے کہ آپ کو اس ویزے کے اختتام سے پہلے بعض ناخوشگوار واقعات ہونے کی وجہ سے آپ کو مختلف قسم کی ہی ویزا جو ہے درخواست کرنی پڑ جاتی ہے. لیکن آپ آئے تو اس ازدواجی جو ویزا ہے اس بیس پر آئے تھے، لیکن یہاں آ کے تو جو دوسری پھر وہ اقسام ہو جاتی ہیں، اس میں ایک تو یہ ہے کہ وہ انگلش میں اس کو بریوڈ پارٹنر یا آپ اس کو سوگوار شریک حیات جو ہے، اس صورت میں آپ کو درخواست جو ہے وہ ویزا ختم ہونے سے بہت قبل ہی بازگشت کرنی پڑ جاتی ہے. یا یہ ایک اور ہوتی ہے کہ وہ جو گھریلو تشدد والی، وہ میرے ساتھی گھریلو تشدد والی اپلیکیشن پر جو ہے وہ بعد میں بات کریں گے، تو آپ وہ سنیں. اور جو تو ہے کہ سوگوار جو شریک حیات بریوڈ پارٹنر کی اپلیکیشن، وہ اس پر میں بات کروں گا کہ آپ اگر جس کو کہتے ہیں کہ ازدواجی ویزے پر سپاؤس ویزا اسپیسیفک جو ہے وہ اس پر آئے ہوں تو تبھی آپ کر سکتے ہیں. اور اس میں یہ ہے کہ اگر آپ یہاں اس طرح کے ویزے پر ہیں اور اس دوران آپ کا جو برطانوی شریک حیات تھا جس کے پاس انڈیفینٹ تھی یا وہ برٹش تھا، تو ان کی اللہ نہ کرے ان کی وفات ہو گئی ہے، تو اس صورت میں قانون آپ کو اجازت دیتا ہے کہ آپ فوری اس ویزا توسیع کی بجائے جس کے لیے آپ کو تنخواہ اور یہ وہ چیزیں شو کرنی ہوتی ہیں، آپ جو ہے وہ مستقل سکونت کی جس کو انڈیفینٹ لیو ٹو ریمین کہتے ہیں اس کی درخواست اس صورت میں ڈالیں. اب وہ کہتے ہیں کہ آپ ان کی وفات کے فوراً بعد اور ویزا ختم ہونے سے پہلے کسی وقت کر سکتے ہیں. اس اپلیکیشن کی یہ جو درخواست ہے اس کی فیس ہوتی ہے، اور فیس وہی ہوتی ہے جو مستقل سکونت کی درخواستوں کی ہے. اور جو آج کل جو ہے وہ 2300 اور کچھ ہے، جو 2399 پاؤنڈ جو ہے اس کی فیس ہے، اور 19 پاؤنڈ 20 پینس جو ہے وہ بایو میٹرک فیس جو فنگر پرنٹس وغیرہ وہ جو کارڈ کے لیے وہ گورنمنٹ کی فیس ہوتی ہے وہ اس کے لیے لیتے ہیں. تو یہ تقریباً 2408 پاؤنڈ کے برابر 20 پینس ہیں جی، 20 ہاتھ ہوتے ہیں. تو وہ اس کی فیس جو ہے وہ ہوتی ہے. اور ایک جو یہ ہے کہ ویسے تو یہ ہوتی ہے کہ اگر آپ سپاؤس ویزا اپلیکیشنز جو ہوتی ہیں اس کے پر آپ 5 سال مکمل کر کے جب انڈیفینٹ کرتے ہیں وہ مستقل سکونت کی درخواست، تب آپ کو لائف ان دا یو کے اور انگلش کا سرٹیفکیٹ جو لیول B1 ہوتا ہے وہ کرنے ہوتے ہیں. لیکن اس صورت میں جب آپ سوگوار شریک حیات کے طور پر کرتے ہیں تو فیس تو ہے، لیکن آپ کو لائف ان دا یو کے اور جو انگریزی کا ٹیسٹ جو ہے وہ نہیں کرنے پڑتے. لیکن یہ ہے کہ اپلیکیشن آپ کو کرنی ہوتی ہے. اور بالفرض جو ہے کہ اس طرح کے ویزے پر ماں آئی تھی، باپ ادھر تھا، یا بعض صورتوں میں باپ بھی آتے ہیں لیکن بچے وہاں سے ساتھ آ جاتے ہیں. اگر بعض کا باپ کی یہ دوسری شادی ہوتی ہے، پہلی شادی انہوں نے وہاں کی تھی، وہ بچے ان کے تھے تو وہ بچے انہی پر تھے، اور ان کی جو سابقہ اہلیہ تھی ان کی ڈیتھ وغیرہ ہو گئی تھی، تو ذرا کہ آئے وہ شادی کے ازدواجی ویزے پر تھے، تو بچے باپ کے ساتھ بھی ہو سکتے ہیں اس طرح کے جن کو ویزا چاہیے ہوتا ہے. تو ایسے بریوڈ پارٹنر یہ جو سوگوار شریک حیات والی ہے، تو اس میں اگر درخواست گزار کے ساتھ بچے بھی آئے تھے، ان کے پاس بھی ویزے ہیں، تو وہ بھی درخواست گزار کے ساتھ اپلیکیشن جو درخواست ہوتی ہے ڈال سکتے ہیں، ان کی بھی ڈالی جا سکتی ہے. اور ان کے لیے بھی جو ویزا فیس ہے وہ ہر درخواست گزار کے لیے ہوتی ہے. اور ایسی صورت میں اگر کوئی بچے آئے تھے جب ان کو ویزے جاری کیے گئے تھے پہلے ویزے آنے کے لیے، تب وہ بچے 18 سال سے کم تھے، اب 18 سال سے اوپر ہو گئے ہیں، وہ جو ہے وہ بچے سبھی آ سکتے ہیں. لیکن وہ جو بچے یہاں پیدا وہ تو پھر یہ ہے کہ باپ کی وجہ سے برٹش ہی ہوتے ہیں. تو یہ اپلیکیشن جو ہے آپ کا جو ہے وہ اس صورت میں کی جاتی ہے. اس میں ایک چیز جو ضرور جو ثابت کرنی ہوتی ہے کہ جو یہاں یو کے اسپانسر تھے ان کی حیات جب تک تھی، ان کی زندگی تک آپ اکٹھے رہے، تو اس صورت میں جو بھی خطوط وغیرہ تب تک آپ دونوں کے نام آئے ہوتے ہیں وہ جو ہے وہ جو ہم آفس کو آپ نے درخواست کے ساتھ دینے ہوتے ہیں کہ اس طرح سے آپ اکٹھے رہتے رہے ہیں. اور جو پاسپورٹ چاہیے ہوتے ہیں وہ چاہیے ہوتا ہے، ڈیتھ سرٹیفکیٹ جو ہوتا ہے، ان چیزوں کی ضرورت ہوتی ہے کہ آپ نے یہ کرنی ہے. तो ये मोटी मोटी चीजें थी। मैं समझता हूँ कि आज मेरे ज़िम्मे मेरे साथी जो है वो बाकी आपके लिए बाकी चीज़ों जो बाकी टाइप की दरखास्तें हैं वो उन पर वो बात करेंगे। तो मैं इसके साथ फिल वक्त आपसे इजाज़त चाहूँगा, बाकी मेरे दोस्त जो है वो आपसे बात करेंगे। और आप हमारी जो लाइव स्ट्रीम है इसके नीचे जो भी सवाल हों वो सवाल ज़रूर करें, उसमें हमारे साथी जो है वो जवाब देते हैं। आज भी एक दोस्त की अभी फ़ोन पर वो बात कर रहे थे, तो मैंने कहा था मुख्तलिफ़ किस्म के वीज़े, मुझे अंदाज़ा था कि मेरे कोलीग उस पर बात करेंगे, तो वो भी वहाँ करेंगे, जो अपनी बात रखेंगे। और आप भी जिस किस्म के भी सवाल हों तो वो रखते जाएँ। हम इन सवालों को वो नोटिफ़िकेशन हमारी पिछली पोस्टों पर भी वो नोटिफ़िकेशन हमें आते रहते हैं हमारे दोस्तों को, तो वो जवाब आप देते रहते हैं, कहीं भी आप करें। लेकिन लाइव स्ट्रीम जो हो रही है तो इस पर लाइव स्ट्रीम में ही करेंगे। वो आज जो हमारे कोलीग हैं वो इसी को देख रहे हैं। तो एक बार फिर मैं वो डिस्क्लेमर पढ़ते हुए कि वो उस्ताद जी अपनी अपनी गारंटी पर जान दो हैं जी, तो वही कहूँगा। तो ये है कि आप जो है कि ये हम जेनेरिक एडवाइस जो है आम देते हैं, किसी स्पेसिफिक एक बंदे के लिए नहीं है। तो अगर जो है वो नफ़ा नुकसान के ज़िम्मेदार आप खुद होते हैं उस सूरत में है जी। तो इसके साथ मैं इजाज़त चाहूँगा। शुक्रिया।
We have Mr. Saad Saeed. Assalamu alaikum, Saad, are you there?
Wa alaikum assalam. Yes, I'm here. Thank you very much.
Right.
And hello and good evening to all of our viewers out there. Or if you're watching the repeat or on Facebook or YouTube later on, good morning or good afternoon. Okay, so today I'm going to be talking about settlement agreements. Now, many of you out there must be thinking, what is a settlement agreement? So in the context of employment law, a settlement agreement is an agreement that is put in writing, that is made between the employee and the employer with a view to ending the employment relationship. Settlement agreements are legally binding and they have to be signed by both parties. So when do they usually arise? Well, when the employer has decided to, I wouldn't say dismiss somebody, but to end the employment relationship, then a settlement agreement can be drawn up and agreed between the parties so that they can end that. Or in the case of maybe a redundancy, a settlement agreement can be offered to the person who's being made redundant. Or if there is ongoing proceedings in the employment tribunal, then a settlement agreement can be made between the parties to end those proceedings and to bring the claims to an end. Some of you watching may have heard in the news about non-disclosure agreements. Now, while non-disclosure agreements are specifically agreements to prevent people from talking about various things, they are similar to settlement agreements insofar as you can get confidentiality clauses contained within settlement agreements, making both parties keep quiet about various aspects. But overall, the purpose of the settlement agreement is to make sure that the relationship, the employment relationship, does come to an end. Okay, now, what is their purpose? What's the purpose of a settlement agreement? So there's two ways of looking at this. One is from the perspective of the employer, and one is from the perspective of the employee. Taking the employers first, because normally they are the ones who offer settlement agreements or want to enter into them. There are many purposes why an employer would want to enter into a settlement agreement. One of them is to make sure that the relationship, the employment relationship, actually comes to an end. So to seek clear finality and make sure that nothing else happens afterwards. Another reason for a settlement agreement is to make sure that the employer doesn't face any claims in the courts once the employment relationship has ended. Another one is to provide the employer with protection protection from damage to reputation, protection from losing trade and business, and protection from losing possibly trade secrets. Now, from the perspective of the employee, a settlement agreement can provide, again, clarification, clarity, and finality, and can be something clearly in writing which shows how the employment relationship has ended, and it can help the employees to know exactly where they stand when it comes to moving forward, and in terms of finding further employment after they finish the current employment. Now, under the law, for a settlement agreement to be legal, there have to be certain requirements that have to be met. What are they? Well, first of all, the agreement has to be in writing. Okay, some agreements can be done verbally, but a settlement agreement must be done in writing. It must also relate to a particular complaint, or must relate to particular proceedings within the court. So, for example, it must specify within the agreement itself it relates to the matter of being made redundant, or it relates to a particular claim for discrimination or for unfair dismissal, etc., etc. The settlement agreement must be entered into voluntarily. So employers cannot force employees to enter into these agreements. Likewise, employees cannot force employers to enter into these agreements. By law, they must be entered into voluntarily. They must also contain a clause that the employee has been given the opportunity to receive independent legal advice on the terms of the settlement agreement and on the legality and consequences of entering into the settlement agreement. This is a key part of settlement agreements to protect the interest of the employee from being forced into signing something that they may not otherwise want to. It is a legal requirement that there is a clause, and you'll see in settlement agreements, if you've been through them, that usually what they have is an appendix which contains a certificate which the legal advisor has to sign to confirm, amongst other things, that they have advised the employee on the consequences of signing the settlement agreement. And without that certification and that signature from the legal advisor, the settlement agreement will not be legal or valid. Now, the other requirement for the settlement agreement to be legal is that it must be made in return for a payment. So there must be a sum of money typically offered to the employee for entering into the agreement. In legal terms, we call this consideration. And very, very briefly, I will say to you that a sum of up to £30,000 can generally be tax-free, as long as that sum is given for genuine loss of employment and not for other things. Having said that, whether the payment falls within the category of being a genuine loss of office, or whether it falls into some other category, and therefore whether tax is applicable or not, is quite a complicated thing. But it's very, very important that the wording of the settlement agreement is done properly, so you know whether tax is payable on that payment or not. Okay, now when somebody's offered a settlement agreement, then ACAS have given some guidance on what should happen. So, for example, ACAS strongly recommend that a reasonable period of time is given to the employee to consider the settlement agreement. It is often the case that the employer will want the settlement agreement signed very, very quickly. They will want everything come to an end, and they want to terminate the employment relationship. But ACAS have said a reasonable time must be afforded to the employee. And when we talk about reasonable time, ACAS have suggested a minimum of 10 calendar days. So not 10 working days, but 10 calendar days. Obviously, the parties can agree to a shorter period if it suits them, or even a longer period if it suits them. But ACAS have said specifically the employees should be given a reasonable amount of time to consider the terms of the agreement and obviously seek independent legal advice. Now, whenever there is a meeting between the employee and the employer to discuss a settlement agreement, there is no legal requirement for the employee to be accompanied, but ACAS have strongly recommended that it is good practice for the employer to allow the employee to be accompanied by a colleague or friend or somebody on their behalf. So if we have any employees out there watching who may be on the cusp of entering into a settlement agreement, or may have been invited for a meeting to discuss the settlement agreement, know that you should be given a reasonable time, preferably 10 calendar days, and you can always ask to be allowed to be accompanied, and employers should or are recommended to accept those requests. Okay, now then, so in settlement agreements, typically they have various types of clauses. I'm going to run through some typical clauses that we see, but there are also some rules on clauses, on what kind of clauses can be put within the settlement agreement. So again, we look at this from the perspective of the employer, and we look at it from the perspective of the employee. Looking at it from the perspective of the employer first, an employer would want to typically put a clause in there to make sure that any claims that the employee has brought come to an end. That is, after all, the purpose of the settlement agreement. So it should state within there specifically that the employee is going to withdraw those proceedings or agree that they be dismissed. Or if the employee is contemplating proceedings, the employee would want to put in a clause making sure that the employee promises not to bring those proceedings against the employer. An employer may also want what we call a confidentiality clause. I mentioned earlier about non-disclosure agreements. What does a confidentiality clause do? Well, it stops the employee and also the employer from divulging trade secrets or from keeping parts of the employment relationship secret, not disclosing it to anybody. So this can protect the employer from losing business and other consequences in the future. We also see typically employers putting in what we call non-competition clauses. What is that? Well, that is a clause where the employee is asked not to, or agrees not to, contact any of the business's customers or clients within a period of time, so they don't snatch any business away from the employer. And then we also can see some further warranties given by the employee in the settlement agreement. So from the perspective of the employer, you would want to put in clauses in the settlement agreement which protect your business and your trade and make sure that you are not damaged once the employment relationship is terminated. Now, from the perspective of the employee, well, what clauses would you want to put in? Well, typically, the first thing you want put in is the amount that you're going to get paid for entering into this agreement. So you would want that specifically stated. And as I said before, the wording should be such so that whether that sum is taxable or not, it's made clear. But the first thing that the employee would want is exactly how much they are going to be paid. Another typical clause that the employee may want to put in there is that they would want their employer to provide them with a reference. Now, this can be important because the wording of the reference that will be provided in the future can be agreed. This gives the employee an opportunity to have some input in the wording of the reference, or to at least see what kind of reference the employer would give if they were asked to do that, so that they at least know what is coming. And if they have anything which they disagree with in there, they can raise it in this instance. The employer would also want to see a clause in there in the settlement agreement saying that the employer will pay the legal fees which for the employee to seek the independent legal advice, which I mentioned before. Again, why would the employer want that in there? Well, so that they know exactly how much the employer is willing to pay. It may be that the fees that the employer is willing to pay covers the entirety of the legal advice, or it could be it just covers it in part. But again, the employer would want to see that so they know exactly how much is being offered, and so they know whether they have to pay any more or not. Then we have what we call neutral clauses. Now, these are clauses which would benefit both the employee and the employer. And two typical examples are: one, if the agreement is breached by either side, then there will be what we call some financial penalties or clawbacks. Both sides would not obviously want this to show the other side that any breaches to the agreement is serious. And typically we also see sometimes a clause where both parties agree not to say anything in public that is bad about the other one, or not to publish something which is bad about the other party. And this obviously helps both parties going forward and avoids damaging the reputation of either of them. Now, to finish off with, what I will say then is this. So clauses can be inserted into the settlement agreement as per your needs. So as per the needs of the employer, as per the needs of the employee. There are two caveats to what kind of clauses can go into a settlement agreement. First of all, you are not allowed to insert what we call penalty clauses. Penalty clauses are clauses which penalize the other side and make them stick to the settlement agreement, and they have no legitimate business aim or no legitimate justification for those clauses. The other thing that is not allowed is there are some exceptions to some types of claims which you are not allowed to exclude. So, for example, from an employer's point of view, they would want to make sure that the employee doesn't bring any claim at all, but there are a few clauses by law which they can't exclude. So apart from that, anything is allowed. So to finish off with, that is a brief overview of settlement agreements. It is very, very important if any employer or employee is thinking of entering into a settlement agreement that the wording of the agreement is properly drafted. Obviously, for the wording to be properly drafted, you need to go to a solicitor or a legal advisor who has experience in drafting these kind of agreements, because the consequences of getting the wording wrong can be, in some circumstances, quite severe. Thank you very much for listening. If anybody has any questions, obviously put them through the chat, or you're welcome to email us during the week or in the future. Mr. Basharat, back to you.
Yeah, thank you very much, Saad. That was very succinct exposition of a very interesting area of law where both parties can part company happy, or perhaps not, unless advice is properly obtained. Thanks very much. Do stick around, Saad. I'm going to bring on our colleague Adnan Mahmood in a minute. He will be talking about non-molestation orders. That is to say, orders which prevent one party from going back to a house or to contact or to basically meet children or a former partner or spouse. And if you have received one, how do you deal with it? If you're the subject matter of one, or if you need to obtain one to protect your own safety and that of your children, how do you get them? I'm going to be asking my colleague Adnan Mahmood, who will be joining me any minute now. I'll just bring him on. Assalamu alaikum, Adnan. Thank you very much for joining us.
Wa alaikum assalam. How are you?
Right, I'm very well. Jazakallah, thank you. And I'm going to make myself scarce.
Okay, Jazakallah khair. Assalamu alaikum to all of the viewers watching, inshallah. I'm going to be talking about what's called non-molestation orders, and also which sometimes run side by side with non-molestation orders, something known as occupation orders. Now, what are these terms? What do we mean by these? These are orders which are made under something called the Family Law Act. The non-molestation order is pretty much what it says on the tin. It's to stop somebody from molesting another individual. And an occupation order deals with occupation rights, which can specifically exclude one particular individual from living in a residence belonging or in which the other person resides. Now, why are these orders there, and why is it that people feel the need to apply for them? Effectively, if you yourself, for example, are at risk of any danger or any harm which may be perpetrated by somebody else who you live with, in typical examples, that may be a spouse, it may be a sibling, it may be a parent, or any other family member. But if that particular individual is there is a threat that that person is going to harm you, your first port of call would usually be to call the police, and the police would provide their adequate protection. But in circumstances where the police cannot intervene, or they feel that there is insufficient evidence to take matters forward, or undertake an arrest, then what you have at your disposal is something known as a non-molestation order. This is an application which is made to a family court, and it is effectively asking the court you're asking the court that, can you please provide me with protection against this individual whom I live with, which, as I said, may be a spouse or a sibling or another family member, who has threatened to harm me or may have harmed me in the past. And what you're asking the court is that if you don't provide me with this order, then there is a real risk that I may suffer harm at the hands of this individual because of specific threats that they have made or specific conduct which they have engaged in. Which is, it could be physical harm, could be, emotional harm, but it has to be something which is real and direct. These applications are sometimes sought together with, as I mentioned, something called occupation orders. And what an occupation order is that in addition to saying that I need the court's protection to prevent this person from harassing me or intimidating me or molesting me in any way, such as, for example, keeping them 100 meters away from me. An occupation order can run side by side with that. And what that does is it says, in addition to excluding, in addition to preventing this person from carrying out any harm to me, I also want this person excluded from the house. And this is something which obviously the court would need to consider based upon evidence. The non-molestation orders can be sought on an emergency basis. So if somebody feels that I need this protection now, and if I inform the other side that I'm about to make this application, then they will carry out whatever threats that they've made against me. And those applications are what are called ex parte applications, meaning urgent applications. Those are presented to the court together with a witness statement, setting out all the necessary evidence, including what conduct this person has engaged in to date and what they are likely to do if the court doesn't provide this protection in the form of an order. And then the court would need to consider that evidence and then decide whether or not to grant an order. Now, what a non-molestation order will do, it's an order in which the judge would dictate that this particular individual, this perpetrator of these threats or harm, is prohibited from contacting the applicant, from whether directly or indirectly, is prohibited from carrying out any harm, any molestation, any intimidation, any threats, whether physical or verbal, and also prohibiting them from encouraging somebody else from carrying out the same. Now, this then if a judge is satisfied with the evidence that this person requires the court's protection, or you require the court's protection, then this order would be put in place. And as I said, if it's done on an urgent basis, it would be done without the other party having an opportunity to say their evidence, say anything in response, because the risk of alerting them to the making of that application may suffer some irreparable harm. Then if an order is made on an ex parte basis, then what happens then is that a judge must order for there to be another hearing, which is usually called a return date, at which the individual against whom the allegations have been made, who we refer to as the respondent, that respondent then has the opportunity to come to court and provide their version of events. Before doing that, however, once an order is made, it needs to be personally served upon the respondent. And what that means is that somebody may, usually a process server, may be instructed to hand deliver a copy of the order to the respondent, such that they are actually given notice, so there's no way that they will be able to escape from it. The power of a non-molestation order is that it carries with it a power of arrest. Now, what that means is that if the respondent breaches any of the terms of the order, then the applicant needs simply pick up the phone, notify the police. The police would then come and arrest that individual and then carry out an investigation as to whether or not those threats were actually, whether there's any substance to them. But it carries that power of arrest. So it has that real force where I mentioned in the beginning, when somebody may have committed, may have threatened to carry out an act of harm against you, and were you to call the police, and the police were to believe that there's insufficient evidence, the non-molestation order changes the dynamics. What that does is it forces the police that they must arrest this individual, because a judge of a family court is already satisfied that you need the court's protection. So that's something that has very serious consequences, a power of arrest, which could then lead to criminal proceedings if it's proven that there has been a breach. Not only is it a criminal offence to have harassed or intimidated somebody or harmed them in any way, but it's also an offence to actually breach a court order, which could bring with it a fine, imprisonment, or the like. So this mechanism, this procedure is in place in order to provide individuals with protection. In the grand scheme of things, these are generally utilized in cases where there is domestic violence. So where somebody has been suffering domestic violence throughout their relationship, a lot of the times when somebody's suffering domestic violence, they can't speak out. They feel that if they do speak out, or if they do notify somebody, they could be, drastic consequences. Or they may feel that they may not want to speak out because they don't want the marriage to break up, or the relationship to break out, or the children to suffer, for example, if there are children involved. So generally, in case of domestic violence, people may stay quiet. But there may come a time where enough is enough, and they feel that they need the protection of the court, in which case this kind of order is available for somebody to make. If somebody wishes to make such an application, it needs to be prepared properly. You can't just make an allegation to say, oh, he said he's going to slap me on one occasion. That may be insufficient. It may just be a one-off event. It has to be prepared properly, such that the judge is convinced that you need the protection because this person is going to cause you harm. And that could be, detailed in a statement which shows a history of abuse, or a threat which may have just been made the day before. So, I had one such case where we had to apply for a non-molestation order when only the day before the respondent had threatened to kill my client, and hence we had to go running to the court, quickly prepare an application on an emergency basis, present the evidence to the court ex parte without the other side being there. Managed to convince the judge that an order was needed, which was then granted, and then we had a return date where the respondent gave evidence, and then the judge, because there was a conflict of evidence, then what a judge then does is he listed the matter for trial. So, for an applicant, a non-molestation provides them with the protection that they need against any risk of harm or intimidation or harassment or any form of molestation. For a respondent, however, the case is slightly different. Sometimes a respondent may feel, no, these allegations against me are entirely false, and I want to defend them. So what do you do if you're ever served with a non-molestation order? It may come as a shock. The first thing you should do is seek sound legal advice so that you can understand the procedure involved, understand what your options are. In summary, a respondent's options is that they go to the return date when the court has relisted the matter and present their version of events. Now, you could say, I completely oppose. The allegations that are made against me are entirely false. And I want the court to examine the evidence, hear from the applicant directly, hear from me directly, consider all of the documentary evidence that may be available, and then make a decision as to the truth of those allegations. If that's the case, then what happens at the court? What the court would do is it would give certain directions for the parties to file their evidence, and then list the matter for a trial, a fact-finding hearing, which is where both the applicant and the respondent will sit in the witness box and give evidence to the court, and the court would hear the evidence, hear legal submissions on their behalf, and then make a decision whether or not those allegations were in fact true. That's in the event of somebody opposing. However, in some instances, a respondent may say, I don't want to fight this all the way. Yeah, non-molestation proceedings can be very, very costly, very time-consuming, very stressful on the mind. So what they may decide is that, look, I don't want to contest this. I don't want to admit to it either. I don't want to admit to any of the allegations. But what I am prepared to do is at least promise to the court that I'm not going to do what the applicant is alleging that I'm going to do anyway. And then what can then be offered to the court is what's called an undertaking. This is a promise. It's effectively a legal promise which a respondent gives to the court to say, I do not accept the allegations, but nevertheless, I'm prepared to accept whatever the order the court, whatever terms of the non-molestation order would ordinarily be made, and I will not breach those. I will promise that I will not harass this individual or contact them or intimidate them in any way, because I wouldn't have done that in any case. And in those circumstances, that's called an undertaking. The difference between an actual non-molestation order and an undertaking is that an undertaking doesn't carry with it a power of arrest, which means that the applicant can't simply just pick up the phone, even if it's a false allegation, call the police, and then the police are then obliged to arrest that individual. But what it does do is that it ensures that the individual giving the promise to the court abides by it, because it carries with it it's potentially contempt of court. If you're found to have made a promise to the court and then you've subsequently breached that, then you could be committed, and that would mean it could follow with a fine or even imprisonment. So that's another option, is to give an undertaking to the court. Final option is that a respondent may feel, well, I am guilty. I have done what's been alleged of me, and in those circumstances may just accept that the non-molestation order remains in place. In which case that would be the end of the matter. But obviously, that order then provides the applicant with that protection, and the respondent is then obliged to ensure that they comply with the terms of the order. Otherwise, there is a real risk that they could be arrested. How long does a non-molestation order last? It can last anywhere between 6 months to a year. It cannot be indefinite. I myself was involved in a high court case, in the case of Mandra versus Sheikh, where the judge agreed with the proposition that I put forward, that a non-molestation order was never intended to be indefinite. It has to have a time limit. And in that case, an earlier judge had actually made a non-molestation order with an indefinite period. The order actually specifically said this order will remain in force indefinitely, which meant that my client had a power of arrest looming over his head infinitum. And that cannot be the case, because the statute doesn't allow for that to happen. And the judge in Mandra versus Sheikh made absolutely clear that it should have a specified time period, usually in practice between 6 months to a year, or it specifies that it's made until further order, and that's only usually provided for when the proceedings are still ongoing and there would need to be another hearing. So, in a nutshell, just to summarize, if you are an individual who you feel that you are the victim of domestic abuse or harm, you don't even have to have a history of abuse. It could be very recent. But if you feel that, I need protection, because if this individual is allowed to reign free and carry out the threats that they've made against me, then I or myself or my children may suffer irreparable harm. And in those circumstances, then your remedy is to apply to the court for a non-molestation order. I would strongly advise, if that is the case, seek legal advice so that the application can be made properly with all of the facts presented to the court, and and then the risk, the chances of getting the order are much higher. If, however, you're a respondent and you've been served with an order, a non-molestation order, or even an occupation order, it's imperative that you act very, very quickly, that you seek legal advice so that you can know what your options are. A lawyer will be able to assess the application and tell you what are the strengths of any defense which you may have, if you have any, and then take the appropriate steps to ensure that you're properly represented at any hearing. Additionally, if a non-molestation order has been made against you ex parte, meaning on an urgent basis, then it's extremely important that you do abide by its terms, even until the return date. Because it's court order, and if you breach it, if for example the order says you are not allowed to contact the applicant, whether by telephone, by text, or by email, or any other form of communication, and you then subsequently do so, you could be at risk of being arrested. So it's extremely important that you abide by its terms and then seek legal advice to see what options you have. And if your instructions are that you want to have the order overturned, then obviously your application is presented properly. I hope that summarizes generally what a non-molestation order is and an occupation order. And if there are any questions about that, I'm sure my learned colleague Basharat will take those questions and pass them on.
Yeah, thank you very much, Adnan. Jazakallah khair. That was very helpful. Bring our colleagues, Mr. Saeed and Mr. Sadiq Subhani, back in. So we've had some very detailed and clear explanations of the different areas of law that we're covering today, whether it's immigration law and extension application, which Mr. Sadiq, for many of our viewers who speak Urdu or Urdu and English, that it's a clear explanation in Urdu. Saeed has explained settlement agreements, and these are very important, particularly in current times when people are looking to actually either leave employment, or they may well be, given the economic uncertainty and circumstances, if you're not being made redundant, there's some sort of settlement being reached. There you will need some good advice, some clear advice to make sure that you're not surrendering anything which could be a problem or a prejudice to you getting a job in the future, but equally it could be a financial or some other matter which you need properly assessed, and you need advice about that. Now, what Adnan spoke about, there's clearly been serious difficulties in marriages, what have you, due to the lockdown, with people having a lot of difficulty amongst themselves. And in many cases, non-molestation orders are being obtained on an urgent basis without notice, what is known in Latin ex parte, on the basis of one party only going to court. And as Adnan clearly said, if you received one of those orders, as sometimes happens in certain communities, you can't call your friend or your uncle or your brother-in-law or someone and say, do you mind having a word? Look, because that will be indirectly breaking the order or breaching the order. You could get them into trouble as well as yourself. So key thing is read it, understand it, and then take legal advice as a matter of urgency so that you know what you're doing. Whether you go to court yourself or you take a solicitor with you, that's a matter for you. But do not act without having clear knowledge. If I come back to you, Adnan, first of all, on the issue of these non-molestation orders or occupation orders, now, many people will want to know, is legal aid available for any of these, generally speaking, not exceptionally? Because many people might say, well, look, it can be quite expensive. And if not, what are their options of funding it? Okay.
Yes. Within family proceedings, only certain areas of family applications qualify for legal aid. Non-molestation orders and occupation orders, like I said, these are known as Family Law Act proceedings. Family Law Act proceedings are covered by legal aid, but only for as far as the applicant is concerned, not for the respondent. And they are only available where there has been, obviously, allegations of domestic violence. Yeah, so in a nutshell, yes, legal aid is available, but this would need to be assessed by a legal aid lawyer. There's two tests. There's one known as a merits test and then a means test. Merits test will depend on the facts of the case, and is it a domestic violence case which warrants legal aid? And means would obviously depend on an individual's financial circumstances. So if somebody is a multi-millionaire then irrespective of having suffered, been the victim of domestic violence, they won't qualify for legal aid. Whereas if somebody is of low means, then it's a different story.
Okay, and in terms of, many people might think, well, they've heard of horror stories about costs, so they can get that information. If somebody wanted to go and obtain an injunction or try and discharge one, they could pick up the phone to you or any other solicitor and say, look, what's it likely to cost me? You would probably want to see the documents that have been sent to them to get an idea of the evidence, the allegations, how much work you'll need to do. And you could quote a fixed fee as well as an hourly rate fee on a sort of confident basis based upon having full disclosure, which could be sent to you by email before they actually go to a solicitor, because the last thing somebody wants to do is, turn up, pay a load of money, and then they get told, actually, we want more and more. So to keep things clear, because people are distressed, they're worried, and they need certainty as much as can be provided. And would you be able to, or any competent solicitor be able to say, well, look, I can price it stage by stage, so at each step of the way how much it will cost?
Yeah, certainly. These kind of applications would have to be priced on a stage-by-stage basis. So for an applicant, as a kind of ballpark figure, if they're looking to make an application on an urgent basis, which would require the preparation of the application together with attendance at court in order to obtain the injunction, they could be looking at anywhere from £1,500 upwards plus VAT. That's typically what most lawyers would charge.
Plus the court fee.
But no, there's no court fee for a non-molestation application or occupation. Family law proceedings don't require payments of court fee. For a respondent, however, if it really depends on what his or her position is. So if his position is to say, I want to oppose and I want my day in court, I want the court to assess the evidence and then make a decision, then it's important. Then you could be looking at anywhere up to maybe £5,000 upwards. It really depends on the facts of the case. But if they just require representation at the first hearing, at the return date, to make their position known, and then sort of assess, because like I said, everything is assessed based upon the evidence, then typically, again, you'd be looking at about £1,000 for that first hearing.
That's very useful. I mean, it's important people do identify somebody who has experience, a firm that is experienced in dealing with these matters, because they need to have clear representation from somebody rather than somebody who speaks their language, who's from the same community or of that nature. You need a professional person to deal with this, because clearly very important things are at play. Coming on to you, Saad, in terms of settlement agreements, you mentioned that both employees and employers should take advice to make sure that any parting of company is done on an amicable basis where both sides can move away having understood the law. In your experience of dealing with settlement agreements, are employers open to negotiation? So if Mr. John Smith or Abdullah Khan turns up at the office and you look at the agreement and it looks very heavily weighted in favor of an employer, I mean, what would you as a solicitor be able to add to that perhaps somebody might not be, who could do it themselves? So what do you bring? What value do you add as a colleague of yours or a solicitor add to this process?
As a lawyer, whenever we analyze settlement agreements, we have to look at whether the tax implications are sound, whether the sum has been properly taxed or properly not taxed. We have to look at the legal enforceability of the clauses, because if they are, as I said before, for example, if they could be a penalty clause, then they may not be enforceable. We have to look at the reasonableness of some of the restrictive clauses, which prevent people from taking jobs in the future or competing. So there are a few things that we can do to check the legal enforceability of various parts of the contract. We have to check whether the settlement agreement itself is legally sound and meets the legal requirements to constitute a settlement agreement, because otherwise it's effectively not worth the paper it's written on. There are quite a few things that we need to do as lawyers. But above and beyond that, when an employee comes to us for advice, they need to know, most importantly, whether they're selling themselves short or not. So,
okay, in terms of employer, why would they need to come to you? Because if I was some employer, I would want to stack up something perhaps in my favor without hopefully breaking the law. So what value do you add to an employer in terms of their benefit of coming to you before they prepare or offer a settlement agreement to an employee?
Yeah, so the value that we can add to employers is to make sure that whatever clauses they put in there are legally enforceable. So going forward in the future, suppose there is something preventing the employee from doing something, and they think 6 months or 12 months down the line, the employee has breached that clause. They want to know that they would be able to act upon that, and it won't be struck down by the courts. It won't be classified as being legally unenforceable. So therefore, they can rely upon that and depend upon that clause because it's been properly legally drafted.
Perfect, thank you for that. And coming on to you, Sadiq Subhani साहब, आपने हमें आगाह किया था कि जो एक्सटेंशन एप्लीकेशंस हैं आपका वीज़े की क्या कहते हैं मज़ीद जो आपने वीज़े को एक्सटेंड करना है कैसे किया जाए, तो आप खुलासा मतलब दे दें हमारे नाज़रीन को, सामीन को, जो अदनान साहब ने कहा है, उस्ताद साहब ने कहा है, मुतल्लिका है क्या कहते हैं एम्प्लॉयमेंट और फैमिली लॉ प्लीज।
बहुत शुक्रिया बशारत साहब। हमारे नाज़रीन, मेरे कोलीग अदनान महमूद और साद सईद ने दो मुख्तलिफ एरियाज, मैंने तो वीज़ों पर बात की है, इन्होंने मुख्तलिफ एरियाज जो हैं वो उन पर बात की है। साद साहब ने जो बात की है वो एम्प्लॉयमेंट के बारे में, आपके काम के बारे में या कारोबार के बारे में है कि आप एक आजिर या एक मजदूर के तौर पर या जहाँ भी मेहनत काशे हैं तो आपके क्या क्या हकूक है, उसमें हर दो अतराफ कौन सा बंदा जो है वो ज्यादती कर जाता है या किसी को नाजायज तरीके से निकाला गया है या इसी तरीके से जो जॉब देने वाला आपका आजिर है तो उसको कोई मामला पेश है। तो हर दो सूरतों में आपको एम्प्लॉयमेंट लॉ जो है वो उसकी जरूरत पड़ती है और साथ साथ ने उसके बारे में एडवाइस की है कि आप कैसे कैसे फिर इन चीज़ों को, जैसे सेटलमेंट एग्रीमेंट इन्होंने कहा, वो यही है कि आपने इस तरह के जब जो मसाइल पैदा हो जाते हैं तो फिर उनको कैसे फिर वो करते हैं, वो उसकी क्या बनी है या क्या होनी चाहिए या किसके हक में ज़्यादा बेहतर जाना चाहिए, तो वो इनकी एडवाइस थी। जो अदनान साहब ने दी है वो मैंने उन्होंने वो दी है कि वो नॉन मोलेस्टेशन ऑर्डर वो उस तरह से है कि जैसे आप वो हुक्म इम्तनाई जो होता है वो उस टाइप की एक चीज़ है या वो या एक ममनुआ जो है चीज़ हो जाती है। तो वो ज़्यादातर फैमिलीज जो होती हैं, खामन जो बीवी या को बच्चों के या घरेलू उस या बात का किसी पड़ोसी के साथ हो जाता है या किसी दोस्त के यहाँ होता है, लोग एक दूसरे पर हमलावर होते हैं, कोई लड़ाई झगड़ा होता है, तो जब पुलिस आती है तो पुलिस एक पर पाबंदी लगा देती है कि आपने वहाँ नहीं जाना, ये इतने दायरे में ये जो होता है आपका सर्कल तो उसके अंदर नहीं जाना। इसी तरह से अदालत जो जज होते हैं वो भी बात सूरतों में अगर एक कोई दरखास्त गुजार वहाँ जाता है कि मेरे लिए क्या है, बिलफर्ज एक बीवी है तो वो वहाँ चली जाती है कि मुझे खामन ने मारा है या इस तरह से, या वो तशद्दुद करने वाला है, तो उस सूरत में ये जो नॉन मोलेस्टेशन ऑर्डर है ज़्यादातर वो सूरतों में लिए जाते हैं कि जहाँ कोई जो है इस तरह के घरेलू नाचाकियों की सूरत में किसी की जान का खतरा आ जाता है तो दूसरे को इस वजह से दूर रखा जाता है कि वो जो बंदा वहाँ पर है जो आ रहे जिसको पहले से ही मसला हो गया है, कोई जख्मी हुआ है या इस तरह का, जरूरी नहीं जख्मी हो, उसको ज़हनी तशद्दुद जो होता है उस तरह की भी चीज़ होती है। तो ये है कि बच्चे या कोई दूसरा ऐसे जो लोग जिसको इंग्लिश में वल्नरेबल कहते हैं, जो लोग माजूरी सी की सूरत हाल में होते हैं, तो उनके बचाव के लिए यह कानून ने ये जो एक सहूलत है वो फ्राहम की हुई है, तो उसको नॉन मोलेस्टेशन ऑर्डर कहते हैं। उसका तरीकाकार होता है, ज़रा के दांतों के चक्कर तो लगते हैं, लेकिन यह है कि उसमें ज्यादती करने वाले के खिलाफ वो आर्डर लिया जाता है। एक पार्टी जो होती है, एक फ्रीक होता है, वो अदालत में इसकी दरखास्त डालता है, तो जब भी प्रोसेस होता है तो फिर अदालतें जो है वो ऐसा आर्डर जारी करती हैं, और जब हो भी जाए तो वो जैसे अदनान साहब ने कहा कि वो लाभ इतना ही नहीं होता जिसके खिलाफ हुआ है, तो वो भी कोर्ट में जाके अदालत में जाके उसको चैलेंज कर सकता है कि ये ज्यादती हुई है, ये इतना लंबा नहीं होना चाहिए, इतना छोटा नहीं होना चाहिए, जो भी है। तो सूरत में बात ये है कि वो पक्की नहीं कि वो मोहर लग गई है उस पर कि वो उनमें तब्दीली नहीं आ सकती, लेकिन قانونی چارہ جو ہے کسی اچھے وکیل سے باعلم وکیل سے تو وہ آپ کی ہر دو صورتوں میں ان مشکلات میں آپ کا معاون ہو سکتا ہے.
بہت شکریہ یہ خلاصہ دینے کا. تو جو امیگریشن کے متعلق جو آپ نے باتیں کی تھی ان پہ آج آپ 1-2 منٹ میں ہمیں خلاصے میں سمجھا دیں آج کے پروگرام میں آپ نے کیا باتیں کی تھی.
وہ یہی تھا کہ جو لوگ ویزے پر آ چکے ہیں شادیوں کے ویزوں پر اس طرح سے یا منگیتر ویزوں پر یہاں آ چکے ہیں تو ان کے متعلق تھا کہ انہوں نے ویزوں کی توسیع کیسے لینی ہے کیونکہ وہ 2.5 سال کے ویزے ہوتے ہیں اس طرح سے. تو اس کے بعد وہ اس کے لیے بھی ریکوائرمنٹ ہوتی ہے, کوئی آٹومیٹک نہیں ہوتا, اس کے لیے ریکوائرمنٹ ہوتی ہے, ویزا فیس ہوتی ہے, آپ نے کچھ چیزیں کرنی ہوتی ہیں. تو اگر ان میں کمی بیشی رہ گئی ہو تو پھر یہ ہے کہ ویزا اپلیکیشنیں یہاں بھی وہ ریفیوز کر دیتے ہیں, ان کے ویزا دینے سے انکار کر دیتے ہیں. اور انکار کی صورت میں یہ ہوتا ہے بعض اوقات تو آپ کو اپیل کا حق جو ہوتا ہے وہ ان کنٹری جس کو کہتے ہیں یو کے اندر رہتے ہوئے اپیل کا حق مل جاتا ہے, بعض اوقات وہ نہیں ملتا. اس میں کہتے ہیں کہ آپ کے جو کلیم یا اپلیکیشن اس کو سرٹیفائی کر دیتے ہیں. مطلب یہ ہوتا ہے کہ اس کو وہ یقین نہیں کر رہتے ہیں کہ جو چیزیں آپ نے کہی ہیں وہ صحیح تھی, وہ سچ پر مبنی تھی. اس میں اگر کہیں آپ نے کوئی ایسا جعلی ڈاکومنٹ لگا دیا یا کہیں اور آپ کی اس طرح سے فیملی لائف نہیں ہے تو اس صورت میں یہ جو اپلیکیشن ہوتی ہے اگر ریفیوز ہوں تو اپیل کے حقوق بھی نہیں ملتے. یو کے میں ہوتے ہوئے تو پھر آپ نے یو کے چھوڑ کے جا کے وہاں سے اپیل کرنی ہوتی ہے دو صورتوں میں. تو اس لیے بہت ضروری ہے کہ وقت سے پہلے خاص کر جو شادیوں کے ویزے کے ایکسٹینشن ہے میں کہوں گا کہ جب 7-8 مہینے رہتے ہوں تو ضرور کسی وکیل کے پاس جو امیگریشن کا کام کرتا ہو, کوئی یہ نہیں کہ کوئی جو امیگریشن کا کام کرتا ہو تو اس کو اپ ٹو ڈیٹ جو ہے وہ نالج کا, کیونکہ امیگریشن قانون جو ہے وہ بہت تیزی سے بدلتا ہے. جیسے بعض ملکوں میں حکومتیں بہت تیز بدلتا سے یہاں پر امیگریشن کا قانون بہت تیزی سے بدلتا ہے. تو یہ ہے کہ بہت ضروری ہوتا ہے کہ آپ اس پر نظر رکھیں. اور خاص کر اب جو بریگزٹ ہوا ہے, بریگزٹ کے بعد یو کے کا پورا امیگریشن سسٹم جو ہے وہ جیسے ہمارے یہاں ہوتا ہے نا کہ درخت کو لا کے پتے گڑائے جاتے ہیں, یہاں ایسا ہی سلسلہ ہے. بہت سی چیزیں جو ہے وہ آپ تبدیل ہوں گی. تو کوشش کریں کہ جو امیگریشن ایکسپرٹ جو وکیل ہوں آپ ان کے پاس جائیں, وقت سے پہلے آپ ان سے مشورہ لیں, ان کے مطابق تیاری کریں. اور بہتر ہے کہ آپ کسی جو ہوتا ہے نا وہ جو جس کا کام اسی کو ساجے, جو جس کام میں ماہر ہے اسی سے کریں, اسی سے کرائیں. تو آپ میں سمجھتا ہوں کہ کسی اچھے امیگریشن وکیل کے پاس جائیں اور 7 بسم اللہ اگر آپ ہمارے پاس آئیں گے.
بہت بہت شکریہ صادق سبحانی صاحب. All that remains for me to say is to Adnan Mahmood and to Saad Saeed, thank you very much for joining me. And I just conclude by telling everybody, reminding you all, as will be clear in the exit from the program, that the advice that has been given for the purpose of general guidance. It is not advice that is to be relied upon for the purpose of you making any application. It is to be used to understand the general principles. You must take legal advice before you make any application. And of course, Aman solicitors or anybody else for that matter would not be accountable should you do it yourself and get it wrong, because the consequence of getting any of these things wrong in the case of breaching a non-molestation order could be arrest, conviction, and possibly a prison sentence and a criminal record. In the case of employment law, you may lose out on a very serious or important right as an employee or as an employer. In the case of immigration paperwork, if you become an overstayer, you could go from getting settlement within 5 years of entering the UK to 10 years, and that may possibly, if it was neglect, result in possible difficulty in getting citizenship. So there are many consequences for all of such applications in such areas of law, and in those circumstances, please make sure you are satisfied that you know what you're doing, or you have taken advice from somebody who's competent to do so. Of course, we're available to do work in the areas we specialize in, and as are many other competent solicitors. Thank you very much for watching. Until next time, goodbye and assalamu alaikum wa rahmatullahi wa barakatuh. I'll just play the exit.